Any other from the petitioner side? I see Mr. Bandari. You are for the petitioner or the...
Your Lordships had put various political
No,
parties.
who are you for?
I am for PTI.
Which side of the divide?
I'm supporting the petitioners, but I am also not saying that Article 191 is completely outs the powers of the Parliament.
I would really like to hear you. Anyone else from this side? Petitioner. तो अगर आप लोग articulate जरा कर लें, we'll take a short break.
My lord, I have actually filed my written submissions.
नहीं, अगर जरा why are you depriving us the pleasure of hearing you? Unless you want to deprive us, that's fine.
No, not at all, my lord. I'm here.
चौधरी साहब भी हैं. तो and of course we won't rush it. आप अपने जवाब भी दे दीजिएगा जो आप देना चाहते हैं. And please, I'm not going to expect this kind of argument for the Supreme Court. Sorry, this is not on.
I'm giving your Lordship extraordinarily good argument. If your Lordship is inclined to ridicule me like that, I will not pay, I will withdraw from the case. I don't allow this.
Please, that's your choice.
Your Lordship has constantly thwarted my arguments again and again. Have a patience to hear my arguments.
ये बताइए जो बेचारे लोग जेल में पड़े हुए हैं ना, छोड़ेंगे नहीं हम.
मैं बचा रहा हूँ, मैं से हूँ.
हाँ नहीं,
मैं भी नीचे से
कौन फैसला करेगा? एक चीज होती है अमेरिकन आइन में वो लोग करते हैं क्या होता है फिलिबस्टरिंग कि जी चलते रहो. अगर आप समझ रहे हैं कि इस तरह से
मैं ऐसा कर ही नहीं रहा. अभी आपने मुझे
आपको हम सुनते हैं मगर आप हमारी बात को सुनना पसंद नहीं फरमाते हैं.
तो ये बात आधे घंटे से सुन रहा हूँ.
चलें.
If I've got you correctly, if I've got you saying that law is not only the act of the Parliament, because there are rules of 1980. If there were no rules, fine, they could have enacted that law. Because they have the rules of 1980, so that's why they were not empowered to pass any law which was contrary to it.
I would not go to that extent. Assume there are no rules. The question is whether the Parliament can frame this law or not is a question which probably is not free from doubt. I would still say the Parliament can't do it. Rules are imperative. So if your Lordship would look at Article 8, if your Lordship would look at Article 8.
इम्तियाज साहब,
Sir,
ये सिंपल हो गया है. आप ये कह रहे हैं कि इस आर्टिकल में एक्सप्रेशन लॉ जो इस्तेमाल हुआ है, this excludes an enactment of the Parliament.
no, my lord, I am not saying this at all. I say law has a larger composition than the act of the Parliament.
So we are, at this moment, we are only concerned with an act of the Parliament.
Your Lordship has asked me a question, what is the scope of the word law?
Yes,
and I am trying to assist your Lordships.
In this case, it's not relevant because the law has already come.
My lord, I am saying that this law, your Lordship's assumption is that since the word law has been used in Article 191, therefore the Parliament can make this law. I am trying to show to your Lordship it is not the case.
I'll take you back to my original question,
Please, Lordship.
where under a constitutional power, this court has framed rules. Do they stand on a higher footing than ordinary legislation?
Yes, my lord, there are judgments to that effect rendered by your Lordships.
Can I ask a question as well? When the Constitution makes a distinction in different articles using the Act of Parliament and using the word law, so how do you see that distinction? So for example, in 191, they could have said subject to the Constitution and Act of Parliament, but instead of saying that, they've used the word subject to the Constitution and the law. There are other provisions of the Constitution which don't use the word law, but use the word Act of Parliament. So there is a clear difference between an Act of Parliament and the word law. So what do you understand by the word law? Because this provision of making rules is subject to the Constitution and the law.
The framers of the Constitution were conscious of the distinction between an act of the Parliament and the law. While they envisaged that law includes judge-made law and other variations of the law, Act of Parliament was specifically used in a particular sense. And they can't be used interchangeably.
And whether this enactment, Act of Parliament, cannot be considered as law?
My
Is it
lord,
not a law?
in ordinary parlance, there may be impression.
No, I'm talking specifically
But
about this.
within
Whether
the
this is law.
context of Article 199,
This is not law.
it is the constitution and law. It would mean law in a broader context. And what are those? Laws which are protected under Article 270AA. Usage or customary practice having the force of law in terms of Article 8, and judge-made law, the judicial precedents which your lordships have given time to time to the people of Pakistan to show to them what law is.
I got your point. You say that every usage, custom can be considered as law, but cannot be considered as act of the parliament.
Yes.
Whereas act of the can be considered as act of the parliament as well as law.
Yes.
So then it is not a law.
I am saying the context in which the word law has been used in the phraseology of Article 191 manifests that this is not an ordinary act of parliament. It means the law which has been rendered from time to time in the form of judgments of the Superior Court.
अब आप इम्तियाज साहब,
Do you think, or are you arguing that it is the exclusive power of this court under Article 191 to make rules?
Absolutely.
And those rules, once that power has been exercised, whether by specifically making rules or through law that is judge-made law, ordinary legislation cannot override that because there is no legislative competence to do that in terms of item 51.
That is precisely my argument. I will go a step further.
Vicky, before you do that, that's very interesting. I was just recalling the equivalent provision in the Indian Constitution is Article 145 relating to the rules of the Supreme Court. Now this has very interesting language. It is subject to the provisions of any law made by Parliament.
Yes.
The Supreme Court may from time to time with the approval of the President make rules, etc. So here, in relation to law, they are clarifying it is statute law or made by Parliament. Whereas in our case, it is just law. So the rules, the law includes any decision of the court which sets out the practice and procedure of the court. And to that extent, statute law cannot override it, cannot supplant it, cannot whittle it down until the court itself revisits that law on the judicial side. It cannot even be done by the full court sitting on the administrative side.
Can't be.
Go back, because there is a certain equivalence between what the court can do on the administrative side to make its rules and what Parliament can do maybe in terms of statute law. But it seems to be that use of, speaking for myself, the use of the word law includes case law or judge-made law. Even the full court on the administrative side cannot overrule that. So this rule, which is supposedly overruled by sections 2 and 3, master of the roster, that is judge-made law. And therefore, even the full court sitting on the administrative side can't do it unless the court revisits that principle on the judicial side.
Imtiaz Saab, Imtiaz Saab, how will we read into this provision 191? It's a constitutional provision. We'll have to read into it that the law only means judgment law. फिर अगर आपका argument ले लिया जाए तो इस law expression से enactment is excluded, but even a usage or a custom override a rule made by all of us.
My Lord, my submission is as follows. Allow me, just follow your Lordship's conclusion. My Lord, the Constitution as I read it, and I make submission with respect to your lordships, the Supreme Court of Pakistan has held that notwithstanding the rules and the rules which are framed under the constitutional scheme, they are on a higher pedestal than ordinary law. Even conventions which have been judicially recognized by the superior courts are constitution by themselves, and the parliament cannot encroach upon them. This is
next point.
इम्तियाज साहब पहले इस fundamental उसको clear कर दें. Do we have to read into the expression law that it is only confined to the judgments of this court and the precedent?
Your lordship will appreciate the contours of the word law, which has been used with reference to the Constitution in terms of Article 181 and the scope of that word. And if your lordships come to the conclusion that this includes the case law rendered by the superior courts have said that even conventions, if they are proven before the court in the constitutional domain, they are the Constitution themselves and violation cannot take place.